I'm a big believer in second chances, even for people who commit serious crimes. Who deserves a second chance? Who gets one? And who decides? I'm Jessica Henry, and I'll be your host of Just Justice. I'm a former public defender, a professor of justice studies, and an award-winning author. And I'm excited for us to find new ways to put justice back into our criminal legal system. Hello and welcome to Just Justice. My name is Jessica Henry and I'll be your host. Today we have the pleasure of talking with Eve Hanan. Eve is the Associate Dean for Faculty Development and Research Director at the Misdemeanor Clinic at the UNLV School of Law. She previously taught at the University of Baltimore School of Law, in the Juvenile Justice Project, and the Mediation Clinic for Families. Eve has substantial litigation experience at the trial and appellate level as a longtime public defender. Eve practiced as an appellate attorney for the D.C. Public Defender Service and as a trial attorney for the Committee for Public Counsel Services in Boston. She also worked to develop statewide litigation strategies for the Maryland Office of the Public Defender. Eve also holds a master's in creative arts and therapy. Thank you so much for coming on the show, and welcome.
Thank you, Jessica.
As listeners know, Just Justice is a show about second chances in the American criminal legal system, and I have invited you on the show specifically because you kind of blew my mind. You wrote an article called Terror and Tenderness in Criminal Law, and it was so compelling I had to read it twice, and it just raised so many great issues about second chances in certain contexts, about discretionary release and clemency and compassionate release and second look laws, all the things that we've been talking about all season on this show. And you made such fascinating points that I wanted to bring you on to unpack what you had to say and to help us think through some of these important questions from a lens that maybe we hadn't considered before. So that's why I'm so excited to talk with you. But before we get there, I'm just wondering if we can talk a little bit about you and your career. You're currently the Associate Dean and a professor at UNLV School of Law, and before that, you were a public defender, and you did trial work, and you did appellate work. And I'm just wondering what you learned from your time as a public defender that helped frame your thinking about criminal law and our current criminal legal system.
Sure. So when I graduated from law school, I knew that I wanted to be a public defender. That was really the only course that I wanted to take because I saw it as both human rights and civil rights work. But I had such an education in the problems in the criminal legal system from day one as a public defender, from seeing primarily incredibly low income people being over-policed, over-prosecuted without any resources on really an assembly line from their first contact with the police officer to prison. I also learned how much a defense attorney can do to help along the way, but also how intractable the system is as it is. And that, of course, was reinforced, as you know, when you do appeals, you realize how hard it is to undo not only wrongful convictions, but unfair results and harsh results. So when I transitioned later into academia, I really came on board with a full career's worth of problems that I'd seen in the criminal legal system that I wanted to understand and unpack and talk about on different levels.
You're also a licensed therapist with an MA in creative arts and therapy. And the reason I'm bringing that background up is because, we're going to be talking on the show about emotions and the impact of emotion on the law. And I'm just curious how you think your therapeutic background influences your perspective on criminal law and the legal system.
Criminal law is an area of law where you see emotions front and center, whether it's anger or rage at defendants or great sadness from the family of defendants when they get sentenced. There's so many emotions at play in criminal law, but I also think that emotions play a huge role in our political life, and criminal law is very political. As we see, politicians who want to be tough on crime or smart on crime are oftentimes evoking a lot of emotions, which is something that I write about now. So I took a break from the practice of law and I got a degree in creative arts and therapy because I thought there was something really missing from my life as a lawyer. And the law really tries to pretend as if it doesn't involve any emotions at all, that it's purely rational, purely fact-based. I think of my 1L law students, my first year law students, who are reading these cases with horrible facts where terrible things happen to people. And we're asking them to ignore all of that and just answer a question about jurisdiction or interpret a statute. So from day one, they're really taught that emotions don't matter. And yet, if you're a trial lawyer, emotions really make or break a case. And when you talk about policy and criminal legal policies, emotions generally carry and shape what happens.
That's a perfect segue. So let's talk about your article, which is named Terror and Tenderness, Two Significant Emotions. Where does the title Terror and Tenderness come from?
So I took this title from a line in a book that's written by Catherine Temple, who is in the English department at Georgetown, but she writes about law and literature and law and emotions in literature. So Lord Blackstone was a jurist in England who wrote commentaries on the law of England when the US was just a set of colonies. Those books, Blackstone's commentaries, really formed the basis of our laws here and continue to be cited. Blackstone is still cited by courts, the Supreme Court. So why does all this matter? Well, Catherine Temple is telling the story of a part of Blackstone's commentaries where he's talking about a judge asking a defendant who's appearing in court for the first time, and that defendant is supposed to plead guilty or not guilty, just like defendants do in courts across the US all the time. And the defendant is refusing to enter a plea of guilty or not guilty. So the judge, this old English judge in Blackstone's commentaries, takes the defendant away, has him taken away. So the judge has the defendant taken away and has weights placed on his body, one after the other, which will eventually crush and kill the defendant. It's called peine forte et dure, which means harsh and strong punishment. And if the defendant says, okay, I'll plead guilty or not guilty, he'll get taken back into court. But if he refuses to plead, then he'll be killed by the weights. So the defendant gets brought back into court. And then the judge is very kind and solicitous and takes his plea and treats him with great dignity and respect when this defendant comes back in. So as Catherine Temple is retelling this story from Blackstone, she says, both terror and tenderness are juridical techniques. And what that means is judges use fear and they use kindness and gentleness in order to secure good behavior or in order to kind of control the defendants in front of them. So that's where I got terror and tenderness from.
Oh, I love that. By the way, I love that story. It's so interesting. Like the judge is about to murder for not entering the plea. And then when he gives in to the judge's technique, all of a sudden there's kindness waiting for him.
Yeah. And just to point out the difference between getting murdered or not is just saying not guilty versus refusing to say anything. But the court is so demanding of that speech from the defendant. The judge had the authority to literally kill the defendant if the defendant didn't say it. Yeah.
Right. But the judge had to exercise control. And it was, literally life or death, whether he was able to master that control. So interesting. You also, in your article, use the phrase the emotional registry of leniency in the context of criminal law and procedure. What is that?
So emotional registers, I think of it as like a climate or an atmosphere or a sort of, if you're playing music, it would be the key that the music is being played in. It isn't what's being played, but it's the key that it's being played in. So what's the mood in the room? What's happening? And this emotional register of leniency is really about this feeling that everyone in the court is going to be kind and it's going to be nice and is going to do the best they can for the defendant or the accused person who's in front of them. Or if it's in the prison context, for the prisoner who's asking for a release. And in public, it's this idea that we have a very harsh, scary criminal system where you can be sent away to prison for life, even as a juvenile, even as a child. Oh, but it's okay because there's a lot of good people in the system and they're going to keep an eye on you and they'll be thinking about ways in which to make the system fair for you and less harsh for you.
And that's not really how it always goes, right? And, even sometimes when someone is shown mercy, there's an element about mercy that can be sort of a question, right? You call the use of mercy as a spectacle. You sort of say that the use of mercy, both in history and in the modern context, has been used as a way to exercise control over people. Can you say more about that? Can you set this up for us?
Sure. So I'm not a legal historian, but when I started reading more about what happened in England during the Bloody Codes, which really went on for a few centuries to the 1800s, really, this was a period of time in which many crimes, all felonies for the most part, were punished by death. And the idea was really a tough on crime crackdown, control through the king and through the parliament, through making executions the norm, even for crimes like theft. So it was called the Bloody Codes. And I'd always been taught that the central drama was of punishment, public execution, where people come out and they realize that the king is strong and powerful. The government's powerful. It can execute you even if you steal a loaf of bread. And that's often called the spectacle of the scaffold, which is what Michel Foucault called it, or it's called the theater of punishment. But when I started reading more about that time period, what I learned was that in a lot of jurisdictions, they didn't execute at all, or they only rarely did. And they most often sentenced to death and then pardoned. And that the theater of pardoning someone who's sentenced to death was perhaps more powerful than the theater of punishment. To say, I'm a king, I'm a judge, I'm the person in charge here, I could kill you, but what I'm doing is I'm sparing you, I'm granting you mercy. And that this was done incredibly strategically. It was a political decision not to execute people sentenced to death in order to convey a message about how fair, how merciful, how beneficent the leadership was.
And let's just take that as an example. Let's just take that idea of a pardon, pardoning on high. So, like the ability to be like, I'm not going to allow you to die after all. Yeah, you know what a huge power that is. And that's essentially what the president has with his pardon power, what governors have with their clemency and pardon powers. But you have, in this article, discussed that the act of clemency really has this emotional appeal. It's really more like window dressing. It's designed to temper the appearance of harshness. And I'm wondering, what did you mean by that?
One of the examples that I pull on is former President Obama's clemency initiative. And I want to start by saying that's a wonderful initiative. I totally support reviewing long sentences for clemency, pardon, and other forms of relief. But the way that it was packaged and sold was as a very merciful and kind demonstration of hopefulness. So the website showed a picture of President Obama hugging a woman who had recently been granted clemency through his initiative, and that she was going to be freed and returned to her community. So it's powerful, emotional stuff. But the reality of the clemency initiative is that few people were pardoned compared to the deluge of meritorious applications. So many people merited that consideration, and so few were pardoned, despite having many attorneys enlisted to help in that process. So this is, in my mind, similar to pardon during the Bloody Codes. And I don't mean to suggest that our presidents are kings. I don't think our presidents are kings. But I do mean to say that it serves the same function. You have people worried about long prison sentences for drug crimes. It was an era where people were getting life sentences for possession of crack cocaine. So undoing that is important. But it wasn't undone systematically. And there was nothing done to make sure that similar excesses wouldn't happen in the future. Instead, we're supposed to be reassured by seeing images of the president with one person, two people, a few people who have been released early who merited it.
And, just to be clear about President Obama, what wound up happening is he did issue a tremendous number of pardons, but because he so successfully advertised it, he wound up getting a huge, as you said, deluge of applicants, and they didn't even get through all of them. So there was this promise, but it didn't quite come to its full fruition. And you talk about that in a number of contexts, sort of how things are presented in one way, but then the reality is just different. And one way that you talk about it is in the context of compassionate release. Compassionate release is something that comes out of the Bureau of Prisons. I think they're the ones that named it. But can you tell us what compassionate release is and how is it used? And I mean, is it compassionate?
It was really interesting for me to find out where that word compassion comes from, compassionate release, because what the law states in federal law, a person can be released early from a prison sentence for extraordinary and compelling reasons. And that could be initiated by the prison administration and then without getting too far into the weeds, or by the person in some circumstances as well. So that has generally meant somebody on death's door. They are dying, or they have an illness, they're about to die, and the prison can't take care of them. There's a few other circumstances, but that's pretty much it. So few people, and only at the very end of their life, and not even all of them. But the Bureau of Prisons at some point decided to call this compassionate relief, which is to say that they decided to call themselves compassionate, and that they do something compassionate, or that they're also asking courts to, if it goes to court, for a judge to do. And that decision, I suggest, is branding. It's really to say, sure, people get life sentences. Yes, people die in prison all the time. No, we don't let people out to die at home very often. But when we do, it's because we're compassionate. And it's meant to sort of sell the criminal system as something other than unmitigatingly harsh. So compassionate release did expand with the First Step Act to make it easier for folks to apply. There were some other changes too. But again, I point out that really those applications are not meeting with a great deal of success. They're getting denied in court right and left. States have similar types of mechanisms for, some just call it medical release, which is a bit more honest. But many call it compassionate release too, and yet few people get released. So again, we have this promise of what you could think of as like government with an ethic of care, government with empathy, criminal system, but with some empathy. But in practice, it really doesn't pan out.
Yeah. And you take that sort of critical lens also to sort of the burgeoning movement around second look laws. Second look laws are laws that are being passed. And I don't want to overstate this, but some states are passing these laws that allow courts to take a second look at somebody's sentence, perhaps because the sentence was unjust, or because someone was sentenced as a juvenile, or whatever the particular state law allows for. A lot of people are really excited about these second look laws in terms of their ability to provide a new pathway towards release. But you say there's something sentimental about second look laws. There's something about using these types of laws to smooth over very real concerns about the underlying harshness of the sentences imposed in the first place. And I think that's really sort of the thesis, as you're talking about all these different things. So I'm wondering if you can really help us understand what you mean by that, because on its face, this is the newest and most exciting thing happening to reduce mass incarceration, to get people out of prison. And yet, when I read your piece, I was like, oh, she's on to something. So tell us more about what it is that you had in mind there.
Sure. And I want to start by saying that this idea of going back and reviewing cases where people got long sentences is really important. And those cases should all be reviewed to see, why did this person get 20 years, 30, 40, 50, life and beyond? And there are many mechanisms for that. And as you said, one of the newer ones is second look sentencing, which can be important because it means a judge, and in some cases, it's the same judge as the initial sentencing judge, gets to see that person again and have a second look. So I'm just going to start by saying that's the branding, right? Second look. And that actually is not just descriptive. It is also emotional, a second look, to go back to something, to return, to gaze on someone. Someone isn't forgotten. They've not been thrown away. They're still here and we're considering them again and looking at them. So there's some emotion in that to suggest that, okay, a judge sentenced, let's say, a 19-year-old to 40 years in prison, but they're not going to be lost in a system. Somebody will be looking at them again. And that is not what is really happening. Right? Some people are getting back in some states have procedures where it'll happen automatically after a certain number of years. But we really don't know what that second look is going to be all about, what will be considered. There's somebody at University of Wyoming, Meredith Esser, who's writing about this right now. What criteria are judges supposed to be looking at? Can they consider what happened to someone in prison? Is there a way to say that the judge made a mistake if they don't reduce someone's sentence and let them out? No, we're just relying on the judges. It's just going to be judicial discretion. Again, we're imagining this judge as being an empathetic, compassionate person who is going to make the right choices without a lot of guidelines and without a lot of guardrails. And the other problem with second look sentencing, and I'm definitely not the first to say this, is that I think judges feel much more comfortable sentencing people to long prison sentences when they think someone later down the line, including themselves, could have a chance to revisit it and look at that decision again. But the reality is, it's unlikely that anything's going to change that decision.
So you actually think that second look laws, even though their intention is to allow people a second chance to get out, they could actually result in judges imposing longer sentences because they think at some point these sentences will get a second look by someone.
That's what I'm worried about. And I do not want to argue against second look sentencing because judges right now are sentencing people to terms of years that are way beyond any of our counterparts in Europe or England, like really long sentences. So we do need mechanisms for early release. I'm not saying we don't, but the other path, the path not taken, is reducing the judge's ability to sentence people to such extremely long sentences in the first place.
And I want to talk to you about that in just a little bit when we get to sort of what we can do there. Because if we're not going to be able to rely on the sentimentality of all these other mechanisms, well, we do have to do something. But before we get there, I just want to keep talking with you a little bit more about this idea that you have so persuasively laid out in this article. There's another part of your article that I just need to talk with you about. I need to have this conversation with you. I don't know if you know this, but I am a huge believer in the power of hope. It's something that's a real driving force for me. I sort of stumbled on this as a legal principle back when Brian Stevenson would talk about being oriented towards hope. And when you're looking at some of the cases, recent cases, when we're looking at things like life sentences, in the cases out of England where they struck down whole life sentences, they talk about the right to hope. This is a thing, the right to hope. And you warn that hope in the legal context can actually maintain mass incarceration. And I'm not going to read your whole quote, but you sort of say, and forgive me if I don't do this quite right, central to my argument is that many of the current reform efforts are lauded precisely for the emotions that they inspire, hope and gratitude, rather than for their ability to address the central harms of carceral practices. And so we're back to this idea again, but you took on hope. So tell me, really, do you think hope is just this horrible, dangling thing that allows us to sort of feel better when some things are really just awful and we shouldn't feel good about them in the criminal legal system?
I'm sorry to take on hope. I know it's a hard thing to say. It's better not to hope. But the kind of hope that I think is problematic is tied to sentimentality that doesn't have any clear objectives. It's more generalized. It's hoping that everyone will be just a little more fair. It's hoping that the prosecutors don't have any more guardrails on who they charge and what they charge. But if we get a really great prosecutor who's really fair and smart, then we're hoping they'll do better. So it's sort of where the hope is placed. It's kicking the can down the road and hoping that there are going to be just the right people in the right positions to make a difference. And in a way, that isn't really the promise of law. Like the promise of law is that there are going to be things written down and that it doesn't matter too much who's doing the work, because if they follow the law, it will be fair. That's supposed to be a system of laws, so it doesn't rely on hope. It relies on real limits on the power of the government to destroy people. And at the beginning, when I talk about terror, I'm talking about the fear of absolute ruination, absolutely destroying people through prison, through high fines, and so forth. And we don't have any real guardrails or limits on that. So to hope that just better people will make it better without changing the rules and putting guardrails on, I think is pretty dangerous.
You also talk about hope in the context of sort of exceptionalism, right? That we pluck out these exceptional people or these exceptional circumstances and parade them around and say, hey, look, the system's working so well. Look, I don't know, John Smith was so amazing. And look at what we were able to do for John Smith. And now he's out of prison. But the truth is, there's so many people who are deserving who never sort of get to have that parade or get that opportunity. And one area that you use to illustrate this is parole. Parole is an early release mechanism. And parole is always sort of touted as being about individual merit. What have you done since you've been incarcerated? But you talk about how parole and this idea of exceptionalism about what have you done since you've been incarcerated, it actually hides, it actually obfuscates how harsh the legal system is and how harsh and unreasonable the parole system is. You kind of comment that exceptional people are denied parole all the time. So that fits into your narrative. I mean, what could you add or tell us about your critique of parole within this paradigm that you've sort of laid out for us?
Yeah, so parole, this idea of getting released early because of good behavior, and not just released, of course, released and being under the authority of parole, having a parole officer. But when people are serving long sentences, talk about hope. They hang all their hope on that early parole. And what that does for the prison is it gets people behaving very well, attending all the classes, doing work in the laundry room and kitchen and anywhere else. And for those of us who've worked with people who are seeking parole and applying for parole, what you learn is that if somebody has even one ticket, is what they call it, right? A disciplinary infraction, they got into a fight or they disobeyed a guard, they could be denied parole for that. So you have these folks who have been literally model citizens in their prison, avoiding all conflict, fights, following all rules for decades. And they finally go up for parole. And they have everything there, all their certificates and everything, even sometimes recommendation letters from like the minister at the prison. And the parole officer doesn't really have a lot of guidelines for how they make the decision. And they say, yeah, I'm going to deny you parole because of the severity of your crime. Keep up the good work and we'll see you in 5 years or 10 years, right? So, of course, then the individual prisoner realizes that they're actually not in a meritocracy, right? They've been told that they can earn parole just like they deserve their sentence for a serious crime. But in reality, that's not the way the world works. So hope also works to control the behavior of individuals within the prisons and within the system.
Yeah. And, just piggybacking on what you were saying, it's like one of those things, right? Like if parole is just dangling out there, there's a chance I could get out early. But in reality, no matter what people do, the parole board often just keeps coming back to, well, you committed this crime 20 years ago. And, the crime is static. It can never change, right? So there's this illusion of hope. But if really the thing that's going to keep them in is their crime, then that's it. It's this very cruel illusion of hope that you're referencing. And, along those lines, we've talked a little bit about these decision makers, whether it's the governor or the president in the clemency context or the parole board in the parole context. But you also take on another aspect of second look laws, and that's prosecutors. And the idea of progressive prosecutors being part of the movement towards getting people out or reducing sentences. And, I'm wondering, what are your concerns about progressive prosecutors and what sort of movement there is to include them? And why is that a problem?
So when I talk about progressive prosecutors, I use this framework of neoliberalism, which is kind of like a word that gets used often when talking about economic systems that are totally free market based with no social safety net. I don't mean that. I mean this aspect of it, which is really against institutions and against rules, and 4 entrepreneurial change agents. If you take it out of criminal context, out of the legal context, you might have a company which is failing and they just want a really great CEO to come in to shake everything up, to change all the norms, to lead everybody in a new direction. And that idea of a change agent, a leader, entrepreneurial agent like that has really come into criminal law in the way in which progressive prosecutors get talked about and how they talk about themselves. So the idea is, let's say this prosecutor's office has routinely just been part of an assembly line. Police, prosecution, sentencing, prison, right? Everyone just goes on that assembly line. So the idea is that this new prosecutor comes in and they're going to change everything and make things better because they've got vision and they care and they've visited prisons. Maybe they've been a public defender before and they're going to really make a difference. That person may very well make a difference. And I don't want to say that they shouldn't be elected. They probably can make some decisions around who gets prosecuted and how prosecution happens that relieves a lot of the excess pain and harshness of criminal punishment for many people. So that could be great. But the problem is, again, we're not talking about changing the law. We're not talking about changing institutions. You're just relying on somebody who basically comes in almost like a superhero, I would say. It's almost like a superhero view, where instead of having systems that protect people, systems that are fair, systems that think about fairness and codify it, put it into law, you're just relying on a charismatic leader to make good choices.
Yeah, and that goes right back to your idea about sentimentality, right? Like, if you have the right person in place, it's wonderful. But as soon as they leave, we're back to the same draconian laws, and we don't have that person to sort of look to. So that's a problem. And Eve, I've got to ask you, it's not a great picture that you're painting here with all these mechanisms for getting people out of prison, for addressing mass incarceration. Not a great picture. So what do you recommend? This is going back to what we were talking about a little bit earlier. What kinds of ideas do you have for effectively bringing about change?
I'd like to see more of a harm reduction model. And I'm using language that we sometimes use when we talk about people with serious addiction, making sure that they have access to safe injection sites, for example, right? Safe use sites. I see the criminal system as so remarkably destructive of so many people's lives. And it seems to me that we need to find ways that categorically reduce that harm. So let's start with our progressive prosecutor. You could have a progressive prosecutor say, I'm not going to charge people with prostitution or low-level drug possession anymore. That's my policy. But you could also have that state legislature remove those things from the criminal code and turn them into a civil ticket, which doesn't carry any possibility of arrest or prison or nothing at all. So you may need other services to take the place of what some jails do, because some jails do actually offer some services to people. I realize that, and we don't have much of a safety net. But you would actually change the laws to reduce the amount of harm that the criminal system can cause. Scandinavian countries, many have prison sentences, the longest of which can be 20 years. Or some do. I don't know if many do, but some have prison sentences that cap at 20 years.
Like Norway, 21.
Yes, 21. Yes. So instead of saying, let's review everyone's sentence after 20 years, but sentence them at the outset to 60 years, you can reduce the maximum penalty for many crimes. That's the idea, I would say, and have some really clear metrics for release. Like perhaps somebody should just be released after a certain point if they've had no disciplinary infractions, they have picked up no new cases, they've got a degree while they're incarcerated. Why is it that one parole commissioner or a board of parole can simply say no?
And you know what's so interesting about that? They tried that, right? Parole is a discretionary release mechanism, meaning it's up to the parole board. But some folks on the inside were sort of saying, let's get rid of parole. It's not working. So they moved to these determinate sentences, mandatory sentences that wound up requiring people to serve way longer than anyone expected. So People served more time under these determinate sentencing schemes that got rid of discretion than they would have under the discretionary schemes. But to your point, if we were able to pass laws that made sentences shorter from the outset, we could just get rid of the parole board because people could just be released if they hit certain metrics that right now are hidden from public view.
Right. And if they were released when they hit certain metrics, it would also take the pressure off parole commissioners and others. What we haven't talked about, I don't really write about it in this article, is that pressure to keep people in prison, because the one person who gets released and commits a new crime, well, they cause harm, sometimes personal harm to another person, but they also cause reputational harm to that parole commissioner or that judge who released them. So having clear metrics that are just automatic release, if somebody has had good behavior for a certain amount of time, would take the pressure off there as well. And it would remove the problem that we have, say, in clemency, which is that as soon as you have a new president come in, they have different priorities for who gets clemency or if anybody gets clemency at all, right? So Obama's clemency program ended when he left office. And so what would it be that would be something other than a pardon or clemency? What would be a fair thing to put in place, which was rule bound, right? At the same time, I think you're pointing out an issue, which is that if there's no discretion, sometimes things get harsher.
I mean, I just think this is the push and pull, right? I mean, we are now dealing with a system that's just so large and so Byzantine to navigate, and we have to do something. And to your point, some of the things that we're doing look amazing, but whether they'll actually work or whether they're just illusions, I think remains to be seen.
I think that's exactly right. Another example that comes to mind that I didn't write about was specialty courts, like drug court. You could have a great judge in a drug court, and you can talk to people who go through that drug court. Some of them will like it, some won't. Some will have been sentenced back to prison. Some will get clean and thank that drug court judge for the rest of their life for saving their life. But then if you really look at the numbers, you realize that most people who were addicted to substances or had alcohol problems weren't sent to drug court. They went straight to jail and prison. Only a small number made it into the drug court and few succeeded. So it's this push and pull. Am I saying there shouldn't be drug courts? No, but I think we have to be realistic and not overly sentimental. So Jessica, when I was writing this, I was thinking of another title for it other than Terror and Tenderness in Criminal Law. And my alternate title was Against Enthusiasm, but I decided not to go with that.
I think that's a nice way to end this conversation. I think I like the title that you actually went with better. Eve, thank you so much for coming on the show and sharing these really provocative and important thoughts with us.
Thank you. This has been really wonderful. And I'm excited about listening to the podcast and the other episodes. You have so many wonderful people come on. It's just a great, great show.
Thank you so much. Thanks so much for listening to this episode of Just Justice. If you like what you heard, please follow us wherever you listen to podcasts and tell a friend. To share an idea for the show or to stay in touch, head to jessicahenryjustice.com or find me on the socials at Jessica Henry Justice. See you next time.